This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about patient brokering and referral schemes to health insurance providers that was enjoined by the United States District Court for the Districts of New York, where GEICO again acts proactively against insurance fraud and takes a bite out of crime. GEICO sued multiple healthcare providers for declaratory relief and RICO to take profit and obtain reimbursements from the fraudsters. No-fault insurance was touted as a panacea to increasing insurance rates because of auto accident litigation. It turned into a profit center, however, for dishonest lawyers, healthcare providers, and patient brokers. GEICO, the victim of many healthcare frauds, sued multiple healthcare providers, patient brokers, and other fraudsters, alleging RICO violations, common law fraud, aiding and abetting fraud, unjust enrichment, violation of the New Jersey Insurance Fraud Prevention Act, and seeking a declaratory judgment based on an alleged scheme to collect reimbursement on thousands of fraudulent no-fault insurance claims. GEICO moved against the defendants, seeking an order pending disposition of GEICO's claims in the action. 1. Staying all pending no-fault insurance collection arbitrations and state court collections lawsuits that have been commenced against GEICO by or on behalf of what are described as the Gerling Defendants, and 2. Enjoining the Gerling Defendants and anyone acting or purporting to act on their behalf from commencing any further no-fault insurance collection arbitrations or collection litigation against GEICO. In Government Employees Insurance Company versus Michael Gerling, M.D. et al., the United States District Court for the Eastern District of New York on February 26, 2024, took a small bite out of the crime of insurance fraud. GEICO, an authorized automobile insurer in New York and New Jersey, alleged that Gerling Defendants participated in an unlawful patient brokering and referral scheme wherein the Gerling Defendants provided fraudulent medically unnecessary services to individuals who claimed that they were involved in automobile accidents and covered by no-fault insurance policies issued by GEICO. These were the insureds. In turn, the Gerling Defendants submitted or caused to be submitted thousands of fraudulent no-fault insurance charges for reimbursement by GEICO. According to GEICO, Gerling entered into a patient brokering and referral scheme with the defendants. The Campiro defendants, for example, and various personal injury attorneys would cause patients to be referred to Gerling and New York Orthopedics for surgical procedures, and the Campiro defendants would pay Gerling to perform invasive, expensive, and medically unnecessary surgeries. The complaint provided multiple examples of fraudulent conduct by the defendants. The examples included billing by the Gerling Defendants for procedures not warranted, billing where the insureds were recommended a substantially identical course of medically unnecessary treatment for a single accident, despite the fact that they were differently situated, billing for surgical procedures to insureds who did not have any serious symptoms secondary to any automobile accident that legitimately would warrant the procedures, and false multiple misrepresentations. GEICO alleged that the Gerling Defendants' bills and treatment reports were false and misleading, and sought recovery of more than $2,200,000, already paid to the defendants under the alleged fraudulent scheme. The court first considered GEICO's request with respect to pending and future arbitrations and found that irreparable harm absent injunctive relief existed because GEICO demonstrated that it would face such harm if the Gerling defendants were permitted to continue pursuing collection arbitrations during the pendency of the lawsuit, because those arbitration actions might eventually be at best inconsistent with the court's ruling and at worst essentially ineffective. The court found that litigating the relatively small number of disputed arbitrations would irreparably harm GEICO absent a stay through the risk of inconsistent judgments in addition to money damages potentially not being available. The court found that GEICO had shown irreparable harm. Then it considered serious questions going to the merits, and GEICO has raised serious questions going to the merits. The court rejected the Gerling defendants' patently frivolous objection that GEICO has not yet provided substantial proof for the court to consider other than its unverified complaint. GEICO, however, has provided evidentiary support for its allegations, not just with exhibits attached to the complaint, but with exhibits attached in support of the motion, by specifically alleging an illicit patient brokering and referral scheme, describing in detail the unnecessary and substantially identical treatments provided to dozens of insureds, and identifying specific types of billing misrepresentations with documented examples. GEICO raised serious questions going to the merits. The court then balanced the hardships, and finally it concluded GEICO has demonstrated that the balance of the hardships tips decidedly in its favor. The court concluded that GEICO had demonstrated that a preliminary injunction staying all pending collective arbitrations and enjoining future collection arbitrations was justified. And then, with regard to pending and future collection lawsuits, the court agreed with GEICO that the fragmentation of the dispute into approximately 50 or more lawsuits would nullify GEICO's efforts to prove fraud at a systemic level, impair a federal declaratory judgment action over which the court has taken jurisdiction precisely to eliminate such fragmentation and deprive GEICO of an avenue toward complete relief in any court. In conclusion, the court found that under the circumstances, it had the statutory authority to stay pending lawsuits and enjoin future lawsuits. The Gerling defendants against GEICO during the pendency of this litigation, and it should do so here. The court therefore granted GEICO's request in full and issued an Order 1 staying all pending no-fault insurance collection arbitrations and state court collection lawsuits that have been commenced against GEICO by or on behalf of the Gerling defendants, and 2, enjoining the Gerling defendants and anyone acting or purporting to act on their behalf from commencing any further no-fault insurance collection arbitrations or new no-fault collection lawsuits against GEICO. The security requirement under Federal Rule of Civil Procedure 65C was also waived. In my opinion, the acts of health care providers who join with criminal entities to create thousands of fraudulent claims under the New York and New Jersey no-fault law, whose purpose was to avoid litigation with regard to auto accidents and help reduce auto insurance premiums, are being thwarted by fraud perpetrators. The fraudsters litigate with insurers who have no defense to the cause of the injuries. Since the state of New York and New Jersey are unwilling to simply refuse to prosecute the fraudsters, GEICO has become proactive And the GEICO companies are working to take the profit out of the crime of insurance fraud. If the state won't help and prosecute the fraudsters, all insurers must emulate GEICO if they too are victims of fraud. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and you will be provided with notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 4,750 blog postings. Please tell all your friends and colleagues about this blog and the videos, and let them subscribe to the blog and the videos. They're free. And if you're interested in more detail about insurance, insurance claims, insurance fraud, and insurance law, please subscribe for a very low fee to my Substack publication and go to @bzelma on X, what used to be Twitter. Thank you for your attention.